Welcome to Impressive Cleaning Solutions. My name is Blessing and I'm the founder and director of Impressive Cleaning Solutions. Whether you've recently joined us as a new employee or an existing employee, I hope your experience working with us is positive and rewarding. We're happy that you've decided to join us here at Impressive Cleaning Solutions, and we look forward to a happy and long, successful business relationship as we work together to improve the skills and customer service within our business. This induction video is designed to introduce you to our company. It will set out the rules and regulations, policies and procedures relating to your employment here at Impressive Cleaning Solutions. If you require any further clarification or additional information, please see any of the management or our human resource team, and they will be happy to answer any questions that you have. My wife and I established the business in March of 2017. And when we started, our goal was to build a business that offered first-class cleaning solutions to businesses on the Gold Coast, Brisbane, and to grow in other states and territories. Ever since we've started the business, everything we do, when we go out, when we meet clients, we always want everything we do to be impressive. So that is why we picked the name Impressive Cleaning Solutions, because we wanted our customers and our clients and employees to be impressed by everything we do. One of the things that I believe that set us apart from other cleaning businesses are the core values that we have, which have really built us as a business. And these include integrity, humility, growth, and respect for our fellow workers. And it is my wish that you, the employee, and the employer, and any other parties that we have value these. Our business provides cleaning services and products to clients that have corporate buildings, shopping centers, educational facilities, and apartment buildings.
Joining the employer. Your employment is subject to an initial probationary period, as set out in your contract of employment. During this period, your work performance and general suitability will be assessed, and if it is satisfactory, your employment will continue. However, if your performance is not up to the required standard, or you are generally unsuitable, the employer may either take remedial action or terminate your employment at any time prior to confirmation of your employment. We reserve the right not to apply full capability and disciplinary procedures during your probationary period. At the commencement of your employment, you will receive training for your specific job. As your employment progresses, your role may be extended to encompass new activities within the business. You are expected to participate in any training deemed necessary for you to perform your role at the required standards. The employer has a policy of encouraging its employees to undertake training to advance their career to both the benefit of the employer and the individual. This includes assisting with the costs of training in accordance with any specific agreements for training, the training agreement. However, in the event of termination of your employment, for whatever reason, the employer will seek reimbursements of the owing costs. At the start of your employment, you are required to complete an induction for both general and site, during which all our policies and procedures, including health and safety, will be explained to you. Amendments may be made to your job description from time to time in relation to the employer's changing needs and your own ability. Whenever necessary, you will transfer to alternative sites or duties within the employer's business. During holiday periods, for example, it may be necessary for you to take over other duties normally performed by colleagues. This flexibility is essential for operational efficiency, as the type and volume of work is always subject to change. It is a condition of your employment that you are prepared, whenever applicable, to travel to any other of our sites within a reasonable traveling distance. This mobility is essential to the smooth running of the employer. During your employment, you are required to immediately report to the employer any convictions or offenses with which you are charged. Salaries and wages. Salaries are paid fortnightly. Your pay cycle runs from Monday to Sunday over a 2-week period, and pays are processed on Monday. Pays will be automatically deposited on a Tuesday electronically into the bank account details provided to the employer. You will receive a pay slip showing how the total amount of your pay has been calculated. It will also show the deductions that have been made and the reasons for them. For example, tax, superannuation, and other agreed deductions. Any pay queries that you may have should be raised with the Human Resources Department. If you are overpaid for any reason, the total amount of the overpayment will normally be deducted from your next payment. If this would cause hardship, arrangements may be made for the overpayment to be recovered over a longer period. At the end of each tax year, you will be given a payment summary statement showing the total pay you have received during that year and the amount of deductions for tax and other matters. You should keep this document in a safe place, as you may need to produce them for tax purposes. Pay is reviewed annually. However, there was no guarantee of an increase in your pay as a result of a review. You must attend work punctually at the time specified in your employment contract, or as otherwise agreed by management. You are required to comply strictly with any time recording procedures relating to your work. All absences due to illness must be notified in accordance with the sickness reporting procedures set out in the Employee Handbook. Lateness or unauthorized absence may result in disciplinary action or dismissal. If there is a temporary shortage of work for any reason, we will try to maintain your continuity of employment. With your agreement, we may place you on short-time working or alternatively, temporary leave. If you are placed on short-time working, your pay will be reduced according to the time actually worked. If you are placed on leave, you will receive no pay. You will be paid superannuation in accordance with the employer's statutory obligations. Annual leave entitlements and conditions. Annual leave in accordance with the National Employment Standards, unless otherwise stated in your contract of employment. Your entitlement to paid annual leave accrues over the course of your employment. Full-time employees are entitled to 4 weeks of paid annual leave for each year of continuous service. Part-time and fixed-term employees are entitled to this entitlement upon a pro rata basis. Casual employees are not entitled to paid annual leave. Annual leave accrues and will be credited to you progressively throughout the year. It is the employer's policy to encourage you to take all your holiday entitlements in the current year. You should give at least 2 weeks' notice of your intention to take annual leave of a week or more, and 1 week's notice is required for the odd single days. You must complete the leave request form and have it signed by management before you make any firm holiday arrangements. Annual leave dates will normally be allocated on a first-come, first-served basis, whilst ensuring that operational efficiency and appropriate staffing levels are maintained throughout the year. Your annual leave pay will be at your normal basic pay unless shown otherwise in your contract of employment. The employer may choose to shut down over the Christmas/New Year period. If we do, you're required to reserve sufficient days from your annual leave entitlement to cover the Christmas/New Year shutdown period. If you have not accrued sufficient holiday entitlement to cover this period, you will be given unpaid leave of absence. Your entitlement to public holidays is in accordance with the National Employment Standards, unless otherwise stated in your individual contract of employment. Please refer to your employment contract for your standard working hours or as otherwise agreed by management. An employee working at any site may be issued with a registered key. This key allows you access into the client's sites. This key is your responsibility, and for whatever reason the key is misplaced, please contact management. If you find that you are the last person to leave the client's site, please take on duty of care and ensure the site is securely locked. Personal leave. You are entitled to be paid for personal leave in accordance with the NES, unless otherwise stated in your contract of employment. Your entitlement to paid personal leave accrues over the course of your employment. Full-time employees are entitled to 10 days of paid personal leave for each year of continuous service. part-time, and fixed-term employees are entitled to this entitlement upon a pro-rata basis. Casual employees are not entitled to paid personal leave. Personal leave accrues and will be credited to you progressively throughout the year. You are entitled to take personal leave because you are not fit for work due to a personal illness or personal injury affecting you, or to provide care or support to a family member of your immediate family or a member of your household who requires your care and support because of a personal injury or illness affecting the member, or a sudden or unexpected emergency affecting the member. If your entitlement to personal leave is exhausted, you may take 2 days unpaid carer's leave for each occasion when a member of your immediate family or a member of your household requires your care and support because of a personal injury or illness affecting the member, or a sudden or unexpected emergency affecting the member. You must notify the employer by telephone, either phone call or text message, at least 2 hours before your usual start time. Emails are not an acceptable method of notification. Other than in exceptional circumstances, notification should be made personally to management. Where management is unavailable, you should endeavor to contact another member of the management team, or alternatively, contact the human resources representative. You should try to give an indication of your expected return date and notify the employer as soon as possible if this date changes. The notification procedures should be followed on each day of absence unless you are covered by a medical certificate. If your incapacity extends to more than 5 days, you are required to notify us of your continued incapacity once a week thereafter, unless otherwise agreed. The employer may require sufficient evidence to support your personal/carer's leave for each absence. In particular, a medical certificate or statutory declaration is required if you take 2 or more days leave or take a single day on either side of a public holiday or annual leave. The employer may also request that you provide sufficient evidence for these purposes where it is considered that you have taken excessive personal leave or demonstrated patterns of leave. If you fail to provide a medical certificate or statutory declaration in accordance with the above, you may not be paid for your absence and may be subject to disciplinary action. You should notify management as soon as you know on which day you will be returning to work, if this differs from a date of return previously notified. If you have been suffering from an infectious or contagious disease, or illness such as rubella or hepatitis, you must not report for work without clearance from your own doctor. On return to work after any period of personal leave, you may be required to attend a return-to-work interview to discuss the state of your health and fitness for work. Information arriving from such an interview will be treated with the strictest confidence. Submission of a medical certificate may not always be regarded as sufficient justification for accepting your absence. Sickness is just one of the many reasons for absence, and although it's understandable that if you are sick you may need time off, continual or repeated absence through non-genuine reasons may not be acceptable to the employer. Deciding whether your absence is acceptable, the employer will consider the reasons for your absences and extent of them, including any absence caused by sickness/injury. We cannot operate with an excessive level of absence, as all absences, for whatever reasons, reduces the employer's ability to operate successfully. The employer will not tolerate any non-genuine absences, and any such instances will result in disciplinary action being taken. If considered necessary, we reserve the right to ask your permission to contact your doctor and/or for you to be independently medically examined. Other leave. Please refer to the Employee Handbook for our parental leave and pay policy. Full-time and part-time employees are entitled to 2 days paid compassionate leave for each occasion when a member of your immediate family or a member of your household contracts or develops a personal illness that poses a serious threat to their life, or sustains a personal injury that poses a serious threat to their life, or dies. You are entitled to long service leave in accordance with the relevant laws of the state in which you are employed. Long service leave should be taken as soon as reasonably practicable after you become entitled to it. Please refer to the Employee Handbook for our Community Service Leave Policy. Circumstances may arise where you need time off for medical/dental appointments or for other reasons. Where possible, such appointments should be made outside normal working hours. If this is not possible, time off required for these purposes may be granted at the discretion of management and will normally be without pay. Codes of Conduct. This policy affirms the employer's belief in responsible social and ethical behavior from all employees. This policy clarifies the standards of behavior that the employer expects of all employees. Our employees contribute to the success of our organization and that of our clients. Furthermore, our employees have an obligation to the employer, our clients, and themselves to observe high standards of integrity and fair dealing. Unlawful and unethical business practices undermine employee and client trust. Our Code of Conduct policy applies to all employees and provides the framework of principles for conducting business dealing with other employees, clients, and suppliers. The Code of Conduct does not replace legislation, and if any part of it is in conflict, then legislation takes precedence. This policy is based on the following. Act and maintain a high standard of integrity and professionalism. Be responsible and scrupulous in the proper use of company information, funds, equipment, and facilities. Be considerate and respectful of the environment and others. Exercise fairness, equality, courtesy, consideration, and sensitivity in dealing with other employees, clients, and suppliers. Avoid apparent conflict of interests, promptly disclosing to management any interest which may constitute a conflict of interest. Promote the interests of impressive cleaning. Perform duties with skill, honesty, care, and diligence. Abide by policies, procedures, and lawful directions that relate to your employment with impressive cleaning and/or our clients. Avoid the perception that any business transaction may be influenced by offering or accepting gifts. Under no circumstances may employees offer or accept money. The employer expects cooperation from all employees in conducting themselves in a professional, ethical, and socially acceptable manner of the highest standards. Any employee in breach of this policy may be subject to disciplinary action, including termination. Should an employee have doubts about any aspect of the Code of Conduct, they must seek clarification from management. Safeguards. To prevent the introduction of virus contamination into the software system, the following rules must be observed. Unauthorized software, including public domain software, magazine cover discs/CDs, or internet downloads, must not be used, and all software must be virus checked using standard testing procedures before being used. To control the use of the employer's computer equipment and reduce the risk of contamination, the following rules will apply. The introduction of new software must first be checked and authorized by our IT department before general use will be permitted. Only authorized staff are permitted access to the employer's computer equipment. Only software that is used for business applications may be used on the employer's computer equipment. No software may be brought into or taken from the employer's or client's premises without prior authorization. Unauthorized access to computing facilities will result in disciplinary action up to and including dismissal, and unauthorized copying and/or removal of computer equipment and/or software will result in disciplinary action up to and including dismissal. The purpose of this policy is to provide a framework to ensure that the expectations and rules relating to the use of Internet within the employer are clear. Authorized staff are encouraged to make use of the Internet as part of their professional activities. The use of the Internet to access and/or distribute any kind of offensive material or material that is not work-related leaves an individual liable to disciplinary action up to and including dismissal. The employer will not tolerate the use of Internet at work for unofficial or inappropriate purposes, including accessing websites which put the employer at risk of viruses, compromising copyright or intellectual property rights, using social media in breach of the employer's social media policy, connecting, posting, downloading any information unrelated to their employment and pornographic or other offensive material, and engaging in computer hacking and other related activities, or attempting to disable or compromise the security of information contained on the employer's computers. You are reminded these activities may constitute a criminal offense. The use of the work messaging system is encouraged, as its appropriate use facilitates efficiency. Used correctly, it is a facility that is of assistance to the employer. However, inappropriate use causes many problems, including distractions, time wasting, and legal claims. The policy sets out the employer's position on the correct use of M8. Unauthorized or inappropriate use of work email may result in disciplinary action up to and including summary dismissal. Work email is available for communication and matters directly concerned with the legitimate business of the employer. The employer will not tolerate the use of Service M8 for unofficial or inappropriate purposes, including any messages that could constitute bullying, harassment, or other detriment, personal use, social invitations, private/personal messages, jokes, cartoons, chain letters, or other private matters. Online gambling, accessing or transmitting pornography, social media, transmitting copyright information and/or any software available to the user, or posting confidential information about other employees, the employer, or its customers or suppliers. The employer considers all data created, stored, or transmitted upon the systems as work product, and as such, expressively reserves the right to monitor and review any data upon the systems, including your own usage and history, on an intermittent basis without notice. In addition to this, the employer has the right to protect its business interests and confidentiality. This includes the right to survey, audit, and/or monitor its systems, including but not limited to monitoring sites users visit on the Internet, monitoring time spent on the Internet, reviewing material downloaded or uploaded, and reviewing emails sent and received. Information reports will be available to the employer, which can subsequently be used for matters such as system performance and availability, capacity planning, cost redistribution, and the identification of areas for personal development, social networking, and blogs. This policy sets out the employer's position on employees' use of social networking sites and blogs, whether conducted on employer media and in work time, or your own private media in your own time. Please refer to the Employee Handbook for the details on our social networking and blogs policy. Standards. We maintain a policy of minimum waste, which is essential to the cost-effective and efficient running of our business. You can promote this policy by taking extra care during your normal duties, by avoiding unnecessary or extravagant use of cleaning supplies, time, energy, etc. The following points are illustrations of this. Handle machines, equipment, and stock with care. Turn off any unnecessary electrical gadgets. Keep doors and windows closed wherever possible. Ask for other work if your job has come to a standstill, and start with the minimum of delay after arriving for work and after breaks. Any damage to vehicles, stock, or property, including non-statutory safety equipment, that is the result of your carelessness, negligence, or deliberate vandalism, will render you liable to pay the full or part of the cost of repair or replacement. Any loss to the employer that is the result of your failure to observe rules, procedures, or instructions, or is as the result of your negligent behavior or your unsatisfactory standards of work, will render you liable to reimburse to us the full or part of the cost of the loss, and, in the event of an at-fault accident while driving one of the employer's company vehicles, you may be required to pay the cost of the insurance excess. In the event of failure to pay, the employer has the contractual right to deduct such costs from your pay. It is important that you present a professional image about your appearance and standards of dress always. You should always wear the full uniform, and it should be clean and tidy always. The employer expects all employees to maintain excellent standards of personal hygiene at all times. The following provides a brief outline of the expected attire in each component of the business. However, if you are in any doubt whether any aspect of your appearance or attire is appropriate for your job role, you should contact management. Impressive Cleaning Solution has a uniform that will be provided to all employees, and this must be worn at all times while at work and laundered on a regular basis. In addition to the polo shirt, it is expected all employees to wear black shorts or pants of reasonable standard and cleanliness, as well as black closed footwear. Office employees are expected to dress business casual attire during work hours. Open-toed shoes are acceptable for office employees. However, appropriate PPE gear is to be worn on all site visits, with no exceptions. Office or on-site employees should not wear ripped or soiled clothing of any sort. This is considered unacceptable. For the purposes of safety and appearance, work areas and storage areas must be kept clean and tidy at all times. Health, safety, and welfare. You are entitled to a safe workplace. The health and safety of all employees, clients, contractors, and visitors are the highest priority and cannot be compromised. You must not take any action that could threaten the health or safety of yourself, other employees, customers, clients, or members of the public. At all times, you must comply with all state and federal work, health, and safety laws and hygiene regulations. If you have any concerns about safety or hygiene in the workplace, you should raise them directly with management without delay. Personal protective equipment and clothing may be issued for your protection because of the nature of your job, and if issued, must be worn and used at all appropriate times. Failure to do so could be a contravention of your health and safety responsibilities. Once issued, this protective wear or equipment is your responsibility. You should report all accidents and injuries at work, no matter how minor, via the employer's incident reporting procedure. You must ensure that you are aware of the client's and our fire and evacuation procedures, and the action you should take in the event of such an emergency. Employees, clients, contractors, and visitors to our office or sites are only permitted to smoke in designated areas. If you are working on site, no smoking is permitted during work hours. No smoking is permitted in employer company vehicles, with no exception to this rule. Deviation from this smoking policy may result in disciplinary action. Any exposed cut or burn must be covered with a first aid dressing. If you are suffering from an infectious or contagious disease or illness, such as rubella or hepatitis, you must not report for work without clearance from your own doctor. Contact with any person suffering from an infectious or contagious disease must be reported before commencing work. Impressive Cleaning has a zero-tolerance policy to drugs and alcohol in our office or on our clients' sites, as this jeopardizes our safe work environment. Impressive Cleaning recognizes its responsibility under health and safety legislation to provide a safe work environment for all employees, contractors, and visitors regarding the prohibition of drugs and alcohol. Non-compliance with this policy and any associated procedure by employees, contractors, or visitors may place the person in non-compliance with the employer's duty of care provisions for the workplace, and such non-compliance may result in disciplinary action up to and including Dismissal. The employer recognizes alcohol and other drug dependencies as treatable conditions and encourages those persons who may be subject to dependency to seek assistance from appropriate organizations or support groups. Employees, contractors, and visitors must not be adversely affected by drugs or alcohol while at work or functions. At all times, you must be fit to perform your work safely. Employees found to be in breach of this policy will be subject to disciplinary procedures. Alcohol may be consumed at some employer events. Where this is the case, the employer encourages responsible alcohol consumption, but you should at no time be drunk or behave in a manner which is inappropriate. Employees who are taking any prescribed medication or drugs which may affect their ability to perform their work must notify management as soon as possible. You may be required to produce a medical certificate stating that you are fit for work or specifying any restrictions. The employer may conduct random drug or alcohol testing during all levels of employees. You must submit yourself to drug and/or alcohol testing as soon as reasonably practicable after it has been requested of you. If you are believed to be under the influence of drugs or alcohol at work, you will be required to cease work immediately and be sent home. Any resulting time off will be taken either as personal leave or unpaid leave. You are required to advise us of any condition which may make you more vulnerable to injury while manual handling. If you arrive for work and, in the employer's opinion, you are not fit for work, we reserve the right to exercise our duty of care if we believe that you may not be able to undertake your duties in a safe manner or may pose a safety risk to others. We may send you away for the remainder of the day with or without pay, and, dependent on the circumstances, you may be liable to disciplinary action. General terms and procedures. You must notify the employer of any change of name, address, telephone number, etc., so that we can maintain accurate records. You are expected to devote the whole of your time and attention during working hours to this business. If you propose taking up additional employment with an employer or pursuing separate business interests or any other similar venture, you must discuss this proposal with management in order to establish the likely impact of these activities on both yourself and the employer. You may not, under any circumstances, whether directly or indirectly, undertake any other duties of whatever kind during your hours of work with the employer or while on employer premises. Please refer to the Employee Handbook for the details on our secondary employment policy. We do not accept liability for any loss of or damage to property that you bring onto our site or our client's site. You are requested not to bring personal items of value to work and not to leave any items overnight. We will reimburse you for any reasonable expenses incurred where these are authorized by management. Where you incur out-of-pocket expenses, you must ensure that the expenditure is recorded on a reimbursement expenses claim form. You must provide tax invoice receipts for any expenditure, and reimbursement will occur in accordance with the usual pay cycle. Please refer to the Employee Handbook for the details on our banking and reimbursement of expenses policy. Oppressive Cleaning Company mobile phones, laptops, and other tablet devices are to be used for business purposes only. Any unauthorized personal use may be repayable by you and may result in disciplinary action up to and including dismissal. Personal mobile phones not used for work-related purposes, MP3 players, and other personal devices should not be used during work time other than in emergencies. You should behave with civility toward fellow employees, clients, and members of the public while at work. Rudeness will not be permitted. Objectionable or insulting behavior or bad language may result in disciplinary action up to and including dismissal. You should use your best endeavors to promote the interests of the employer and shall, during normal working hours, devote the whole of your time, attention, and abilities to the employer and its affairs. Any involvement in activities which could be construed as being in competition with the employer is not allowed. Motor vehicles. You must be in a possession of a current driving license and management's authority to drive during the performance of your duties. You must produce your driving license for scrutiny by management at any time as requested. Please refer to the Employee Handbook for more details on our motor vehicles policy. Whistleblowers. If you believe that the employer or any of its employees are involved in any form of wrongdoing, such as committing a criminal offense, failing to comply with a legal obligation, endangering the health and safety of an individual, environmental damage, or concealing any information relating to the above, you should in the first instance report your concerns to management or a company director who will treat the matter with complete confidence. If you're not satisfied with the explanation or reason given to you, you should raise the matter with the appropriate organization or body, for example, the police, the Environment Protection Agency, or WorkCover. You will not suffer any detriment as a result of any genuine attempt to bring to light matters of concern. However, if this procedure has not been invoked in good faith, for example, malicious reasons or pursuit of a personal grudge, then you may be subject to disciplinary action, up to and including dismissal. Capability procedure. We recognize that during your employment with us, you may find yourself less capable of conducting your duties. This might commonly be because either the job changes over a period of time and you fail to keep pace with the changes, or you change, perhaps because of health reasons, and you can no longer cope with the work. If the nature of your job changes, or we have general concerns about your ability to perform your job, we will try to ensure that you understand the level of performance expected of you, and that you receive adequate training and supervision. Concerns regarding your capability will normally first be discussed in an informal manner, and you will be given time to improve. If your standard of performance is still not adequate, you will be warned in writing that a failure to improve and to maintain the performance required could lead to your dismissal. We will also consider the possibility of a transfer to more suitable work if possible. If there is still no improvement after a reasonable amount of time, and we cannot transfer you to a more suitable work, or if your level of performance has a serious or substantial effect on the employer to its detriment, you will be dismissed with the appropriate notice. Personal circumstances may arise which do not prevent you from attending for work, but prevent you from carrying out your normal duties, for example, a lack of dexterity or general ill health. If such a situation arises, we will normally need to have details of your medical diagnosis and prognosis so that we have the benefit of expert advice. Under normal circumstances, this can be most easily obtained by asking your own doctor for a medical report. Your permission is needed before we can obtain such a report, and we will expect you to cooperate in this matter should the need arise. Please refer to the Employee Handbook for the details on our policy regarding personal circumstance and health issues. Discipline in the workplace. This policy sets standards of performance and behavior expected by the employer, together with the procedure to be followed in the event of disciplinary issues. This policy aims to help promote fairness and order in the treatment of individuals. It is the employer's aim that the rules and procedures should emphasize and encourage improvement in the conduct of individuals where they are failing to meet the required standards, and not be seen as a means of punishment. We reserve the right to amend these rules and procedures where appropriate. It is not practicable to specify all disciplinary rules or offenses that may result in disciplinary action, as they may vary depending on the nature of the work. In addition to the specific examples of unsatisfactory conduct, misconduct, and serious misconduct shown in this policy, a breach of other specific conditions, procedures, and practices set out elsewhere in this Employee Handbook, or that have otherwise been made known to you, will also result in this procedure being used to deal with such matters. Rules covering unsatisfactory conduct and misconduct. You will be liable to disciplinary action if you are found to have acted in any of the following ways: failure to abide by general health and safety rules and procedures, persistent absenteeism and/or lateness, unsatisfactory standards or output of work, rudeness toward customers or clients, members of the public or other employees, objectionable or insulting behavior, harassment, bullying, or bad language, failure to devote the whole of your time, attention, and abilities to our business and its affairs during your normal working hours, unauthorized use of our messaging system and the Internet, failure to carry out all reasonable instructions or follow our rules and procedures, unauthorized use or negligent damage or loss of our property, failure to report immediately any damage to our or the client's property or premises caused by you, use of the employer's vehicles without approval or the private use of commercial vehicles without authorization, failure to report any incident while driving the employer's vehicles, whether or not personal injury or vehicle damage occurs. If your work involves driving, failure to report immediately any type of driving conviction or any summons which may lead to your conviction, carrying unauthorized goods or passengers in the employer's commercial vehicles, or the use of the employer's vehicles for personal gain, and loss of driving license, where driving on public roads forms an essential part of these duties of the role. This list is not exhaustive. Occurrences of serious misconduct are very rare because the penalty is dismissal without notice, even without any previous warning being issued. It is not possible to provide an exhaustive list of examples of serious misconduct. However, any behavior or negligence resulting in a fundamental breach of your contractual terms that irrevocably destroys the trust and confidence necessary to continue the employment relationship will constitute serious misconduct. Examples of offenses that will normally be considered serious misconduct include serious instances of theft or fraud, physical violence or bullying, deliberate damage to property, deliberate acts of unlawful discrimination or harassment, possession or being under the influence of illegal drugs at work, and breach of health and safety rules that endangers the lives of or may cause severe injury to employees or any other person. Disciplinary action taken against you will be based on the company procedure when standards of performance and behavior expected by the employer are not met. Please refer to the Employee Handbook for more details on our discipline in the workplace policy. Grievance procedure. It is important that if you feel dissatisfied with any matter relating to your employment, you should have an effective means by which to raise such a grievance and, where possible, have it resolved. Please refer to the Employee Handbook for more details on our grievance procedure policy. Bullying and harassment. The employer is committed to promoting a fair, safe, and healthy working environment in which everyone is treated with dignity and respect, and which no individual or group feels intimidated, bullied, or threatened. Bullying or harassment in any form is unacceptable behavior and will not be permitted or condoned. We recognize that bullying and harassment can exist inside the workplace as well as outside, and this can seriously affect employees' working lives by detracting from a productive working environment and can impact on the health, confidence, morale, and performance of those affected by it, including anyone who witnesses or has knowledge of the unwanted or unacceptable behavior. We have published these procedures to inform employees of the type of behavior that is unacceptable and provide employees who are the victims of personal harassment with a means of redress. We recognize that we have a duty to implement this policy and all employees are expected to comply with it. Harassment is any unwanted physical, verbal, or nonverbal conduct based on the grounds of age, disability, gender identity, marriage and civil partnership, pregnancy or maternity, race, religion or belief, sex or sexual orientation, which affects the dignity of anyone at work or creates an intimidating, hostile, degrading, humiliating, or offensive environment. A single incident of unwanted or offensive behavior can amount to harassment. Harassment can take many forms, and individuals may not always realize that their behavior constitutes harassment. Examples of harassment include insensitive jokes and pranks, lewd or abusive comments about appearance, deliberate exclusion from conversations, displaying abusive or offensive writing or material, unwelcome touching, and abusive, threatening, or insulting words or behavior. These examples are not exhaustive, and disciplinary action at the appropriate level will be taken against employees committing any form of harassment. Bullying is repeated offensive, abusive, intimidating, insulting, or unreasonable behavior directed towards an individual or a group, which makes the recipients feel threatened, humiliated, or vulnerable. Note single incidences of bullying will not be tolerated. Bullying can occur in the workplace and outside of the workplace at events connected to the workplace, such as social functions or business trips. Bullying can be a form of harassment and cause an individual to suffer negative physical and mental effects. Bullying can take the form of physical, verbal, and nonverbal conduct. As with harassment, there are many examples of bullying, which can include abusive, insulting, or offensive language or comments, unjustified criticism or complaints, physical or emotional threats, deliberate exclusion from workplace activities, the spreading of misinformation or malicious rumors, and the denial of access to information, supervision, or resources, such that it has a detrimental impact on the individual or group. These examples are not exhaustive, and disciplinary action at the appropriate level will be taken against employees committing any form of bullying. Please refer to the Employee Handbook for all the details on our bullying and harassment policy. Privacy Policy. While the operation of the Privacy Act does not apply to the employer in regard to any acts which directly relate to the employment relationship between the organization and the individual, and an employee record held by the organization, the employer treats the handling of your personal information and our clients very seriously. Accordingly, the purpose of this policy is to ensure the protection of your privacy in relation to the handling of your personal information. Personal information may be collected during the recruitment process and throughout your employment with the employer. This personal information may be disclosed to other departments within the business for administrative purposes and for the progress of your application. All confidential information will be used for legitimate purposes in accordance with the relevant legislation. Personal information includes information relating to the engagement, training, disciplining, or resignation of the employee, termination of the employment of the employee, terms and conditions of the employment of the employee, employee's personal and emergency contact details, employee's performance or conduct, employee's hours of employment, employee's salaries or wages, employee's membership of a professional trade association, employee's trade union membership, employee's recreation, long service, sick, personal, maternity, paternity, or other leave, and employee's taxation, banking, or superannuation affairs. All reasonable attempts will be made to keep this information relevant, complete, and current. You must ensure that any personal information provided is accurate and current. Considering the above objective, every employee is responsible for the appropriate handling of such information and to prevent unlawful disclosure. If you have access to this information, or such any personal information belonging to another employee or a client of the employer, you must ensure that you maintain the confidence of any confidential information that you have access to or become aware of during the course of your employment, and will prevent its unauthorized disclosure or use by any other person. You will not use the confidential information for any purpose other than for the relevant and related employer processes during or after your employment. Any action in breach of this policy may result in disciplinary action being taken. Equal Opportunities Policy. We recognize that discrimination is unacceptable, and although equality of opportunity has been a long-standing feature of our employment practices and procedure, we have made the decision to adopt a formal equal opportunities policy. Breaches of the policy will lead to disciplinary proceedings and, if appropriate, disciplinary action. The aim of the policy is to ensure that no job applicant or employee is discriminated against, either directly or indirectly, on the grounds of age, disability, gender identity, marriage and civil partnership, pregnancy or maternity, race, religion or belief, sex or sexual orientation. The recruitment and selection process is crucially important to any equal opportunities policy. We will endeavor through appropriate training to ensure that employees making the selection and recruitment decisions will not discriminate, whether consciously or unconsciously, in making these decisions. Please refer to the Employee Handbook for the details on our Equal Opportunity Policy. Termination of employment. All resignations must be provided in writing, stating the reason for resigning from your position. If you terminate your employment without giving or working the required period of notice, as indicated in your contract of employment, you will have an amount equal to any additional cost of covering your duties during the notice period not worked, deducted from any termination pay due to you. On the termination of your employment, you must return all employer property which is in your possession or for which you are responsible. Failure to return such items within 7 days will result in the cost of the items being deducted from any monies outstanding to you. All employer property should be returned to management before your final pay is processed. Failure to do so will result in your final pay being delayed. On termination of your employment, you must return your employer company vehicle in your possession to our premises. Failure to return the vehicle will result in the cost of its recovery being deducted from any monies outstanding to you. This video presentation is only a summary of the key points in the handbook. We ask that you read all the contents of the Employee Handbook carefully and sign and return the acknowledgement form. Thank you for watching. We wish you every success during your employment here at Impressive Cleaning Solutions.